Hello, friends. Today I am discussing with you the latest issue of farmers. That is the farmers' agitation. That is the latest laws on these three laws. But today I am discussing only the legal aspect and not the political aspect. Or I will discuss about the economic aspect. So let us see how we go ahead. Right now, the matter has gone to the Supreme Court, and the Supreme Court has given a chance to both the parties, the agitating farmers as well as the government, to place their point of view before the court. Now let us see the one aspect. Is there any chance for filing a petition or making the petition successful, saying that these laws violate or the constitutionality of the Constitution? That means that these laws are not valid under the Constitution. Can we make this kind of a petition before the Supreme Court? Well, let us examine this point also. What options are available and what are the intricacies of the law in this matter? Article 13 of the Constitution, which relates to the fundamental rights, definitely provides a good scope for making these laws against the Constitution, but apparently these laws do not infringe or conflict with the fundamental rights under the Constitution. Now, the next option, or we can look into that one, what is the other relevant area where a petition can be successful before the Supreme Court. Another is that if the petitioner challenges the basic character of the Constitution, saying that the federal character of the Constitution has been infringed by enacting these laws, there is some scope. But let us examine it and see the intricacies whether this area or this option is available or not. Now, when we say the federal character of the Constitution, means thereby that the states and the center have the exclusive powers on which they can make laws. That means the state can make laws within the state, and the parliament can make laws within the whole of the country. Now, if any law made by the state violates the central law, or any law made by the central government or the parliament, then that will be called infringing, or we call it the violation of the federal character or violation of the basic structure of the Constitution. So that can be challenged if there is circumstances and facts are available. Now, before we go further, let's examine these points little critically from legal angle. What is that? Article 246 of the Constitution provides under Schedule 7 three lists, that is a union list, state list, concurrent list. In all these three lists, there are multiple entries of subjects on which the union government can make laws, state government can make laws, and under the concurrent list, both state and the center can make the laws. Center means parliament. Now, Article 254, Article 254 provides that if there is any conflict between the in the concurrent list, if there is a conflict, then the law made by the parliament will prevail over the laws made by the state. So this is a clear point. Now let's see it a little more ahead of that one. This in state list, there's an entry number 14 and entry 26 and 27. Under entry 14, there's a clearly mentioned agriculture subject. That means that these entries in the state list, entry 14 and 26 and 27 relates to the state list. And on the subject of agriculture, which is in 14, means that the state has got the exclusive powers to make laws. A center does not have the power to make laws. What does it make any sense? On 26 and 27 entries, it talks about the trade and commerce on 26, and 27 it talks about the production, supply, distribution, trade, goods, sales. All these factors are there in 27. So this means that the laws pertaining on these subjects is the exclusive power of the state to make laws. Center cannot make it. If it makes, that means the basic character, the federal character has been infringed. Now it doesn't end here. Actually, there are more intricacies in these laws. There is an entry number 33. The entry number 33 in the concurrent list. In this list, there is a large number of areas which is mentioned: trade, commerce, production, sales, supply, sales, goods, everything is stated therein, where the center can make the laws and the state can also make the laws because it's a concurrent list. Now, what happened is that in 1954, during the Nehru time, there was an amendment that is called Third Amendment of the Constitution. What it did in the Constitution was that after entry 26 and 27 of the state list, two words were added. What were those two words? It says subject to entry 33 of the concurrent list. That means anything which is made, which the law is made by the state, that will go under 33. So that means that the law made by the central will prevail all the times over. And if there is any inconsistency, then the court can take a decision on that one. And the matter goes to the court, and the court can easily form its opinion and decide about it. Now, if you look in these areas, you will find it that there is not much scope for any petitioner to file petition on these lines before the Supreme Court. So, what any other area or any option or any aspect is available? Yes, there are. There is a call that is a content if any of the content, even a word, sentence, full stop, comma, head of the law, if it infringes, it conflicts any of the articles, any one of the articles of the Constitution of India, then to that extent, a petition has got a good scope to get an order from the Supreme Court to make it null and void, that the three laws can be made null and void. But if you examine all the contents of all the three laws, there is hardly any scope. Why? Because I don't find any one of the legal intellectuals or luminaries or any advocates or senior advocates or the experts of this side have raised any issues so far. It looks that it is straight and it does not infringe any content of the law. Now, what is next? There is one little lacuna, and of course, not very strong, but not very weak also. That is whether the procedures were adopted, that the procedure established by law, the procedures established by law were followed at the time of adoption of these laws enacted by the ordinance. Let's examine that one. If there is some scope or lacuna, then it is a fertile point to take up the matter before the Supreme Court to get it inconsistent or violation of the Constitution. Now, what is that? You see, the ordinance was promulgated by the President on 5th of June 2020. And immediately this became a law. Now, the procedures established by law require that within the next 6 months, the first session coming, these ordinance laws should be placed before the Parliament for its adoption. If it is not placed before the Parliament, then the ordinance will lapse after the expiry. And in case the Parliament does not adopt, then also it will lapse, that the ordinance will become null and void. Now, when the government placed these laws made by ordinance in September before the Parliament, what happened over there? In Lok Sabha, there are 542 seats. If you make half of that one, that comes to 243 or something like that. If these members of 243 pass, that's the majority. Then the Lok Sabha means they adopt these laws. The BJP, that we can call it NDA, had its membership much more than the half of the requirement, that is equal to 345. So there was no problem, and straightway the law was adopted by the Lok Sabha. What exactly happened in the Rajya Sabha? That's a, that's a question seriously to be examined. In Rajya Sabha, there are 242 members. That means half is 101. If there is 102, then if they favor 102, that means the law will be adopted. On the day of placing these laws for adoption before the Rajya Sabha, due to coronavirus, the members were not sitting on their seats. Let me say one more point. That's an important point. That is, the opposition at the first instance said that these laws should not be placed for voting, but these laws should be sent to the select committee. And after that, their recommendation, these should be placed before them. Now, normally, laws are actually sent to the select committee, but it is not on the whims of few members of the Rajya Sabha or Lok Sabha to send it compulsory to the select committee. Actually, the majority of the relevant, whether it's a Rajya Sabha or the Lok Sabha, whether it should go to select committee or not, it is the majority which decides. But it was not decided that these laws before adoption should be sent to the select committee. Therefore, these laws were placed for resolution, that means for voting. Now, voting was done by show of hands, but not by pressing the buttons. Because and it's a normal, it's illegal by show of hand also. The members were spread over and they were maintaining a social distance because of coronavirus. On that day, the presiding officer, he puts the laws to vote, asking, raise the hands who favor. They raise the hands. Then he asks the other sides who do not favor to raise the hands. Then on visual counting, he decides whether majority is there voting for the adoption of the law, these laws, or not. He decides that the majority has favor for its adoption and therefore the law is passed, or we call it adopted. And he certifies. Now, to that extent, the procedures have been complied with. Now, prima facie, if you see it, it looks that all the procedures established by law have been followed. But still, you can have an option to take this as a reason to file a petition before the Supreme Court that the procedures as established by law have not been followed, but it has to be examined. It's not necessary to prove it that it is followed or not followed. Why it is so? Why it is so? There is another article that says, Article 122. That is the main problem, the main issue to decide whether these procedures were followed or not. Article 120 says that whatever is happening within the parliament or within the assembly, that does not become a subject of judicial decision. That means the Supreme Court does not have the power to look into what exactly happened inside the parliament. It is the exclusive power of the parliament as well as of the legislative assembly. This is a demarcation of the Constitution, that the judiciary has the exclusive power in the judicial matter, the parliament the exclusive power in making the laws. But as I said, had been saying it, that Indian democracy is still in the process of maturing. And presently, there are possibilities. They may be accepted or that may be rejected. Or it may not be admitted even. Or if it is one is admitted, maybe or may this way or that way may be decided. So it is very hard, but there is a scope to file a petition. But if you ask me, and if I have to give my mind, I think there is very little scope for the Supreme Court to go beyond the spirit of Article 122 of the Constitution. So let us see what exactly happens or what can happen. Right now, that issue is not before the Supreme Court, but there are other issues. They have called both parties, and I understand that Supreme Court is playing great role. Supreme Court knows it, what exactly the problem is and what issues are before the country as well. And they are trying to shape and crystallize the issues so that both the parties, one is, and if you watch the words, what the Supreme Court has said it, they said it, the farmers, कि आपको जिद नहीं करनी चाहिए, और दूसरा लफ्ज़ उन्होंने साथ ही साथ ये कहा गवर्नमेंट के लिए भी कि आपको इतनी जल्दबाजी नहीं करनी चाहिए. देखिए ये दोनों पॉइंट्स लीगलिटी पॉइंट ऑफ से नहीं है, इट्स ए कॉन्शियस पॉइंट. Supreme Court has got the responsibility to maintain the spirit and the conscience of the Constitution. It is a safeguard which have to be maintained by the highest court of the land. With this, I am ending my video and request you to subscribe. When you subscribe means that the next video will come to you automatically. Now in the next video, I'll be discussing with you the economic aspect of all these three laws. Thank you very much, and please take care about yourself and your family, especially old people like me. They have to take utmost care. Thank you once more. God bless you all. Thank you.